Hi, before I start, I would like to introduce myself. My name is Shu Ting with metric number 056088 and I'm currently studying Bachelor of Law in UniSZA and I was born in Kuching, Sarawak, Malaysia. Today, I'm going to talk about an issue is whether movement control order can cause a breach of contract. First of all, due to the widespread of coronavirus or COVID-19, the Malaysian government had introduced MCO in order to control the spread of COVID-19. However, it creates a multitude of legal issues for business. So, what is the meaning of breach of contract? A breach of contract is when one party breaks the term of an agreement between two or more parties. This includes when an obligation that is stated in the contract is not complete on time or when it is not fulfilled at all. So, under Section 74 of Contract Act 1950, an innocent party may claim damages from the party in breach in respect of all breaches of contract. Further, a specific performance is a discretionary remedy granted by the court, and it is under the Specific Relief Act 1950. It is a decree by the court to compel a party to perform his contractual obligations. However, due to the restrictions of movement order, it makes the parties to the contract impossible to perform their contractual obligations. Therefore, what are the legal remedies available if contracting parties cannot perform their contractual obligations? For example, due to inability of personnels who may be in quarantine or who may be unavailable due to other restrictions, or perhaps due to delay or failures in the supply chains of goods or service. In such cases, a party to a contract may be able to avoid their contractual obligations pursuant to a force majeure clauses in the contract, or otherwise under the legal principle of frustrations. In the context of commercial contracts, force majeure is associated with act of God or unforeseen events which render performance of a contract impossible. A doctrine of force majeure is not automatically recognized as a matter of law in such a way that it would be implied to operate in every contract, but parties to a contract may be agreed to include it in a contract. Where a force majeure clause has been included in a contract, the clause will specify certain circumstances in which the contracting parties will be relieved from performing their contractual obligations. In the case of COVID-19, the key question is whether the circumstances described in the force majeure clause captures the current circumstances of COVID-19. Generally, a party who seeks to rely on force majeure clause must prove the occurrence of a circumstances or event described in the clause. If a party seeks to engage a force majeure clause, it should therefore be specified that the relevant force majeure circumstances applies. If a party claims a force majeure event has arisen without any reasonable basis, for example, where performance of the contract is still possible, then this may cause the party to be in breach of the contract for failure to perform, or the other party may in the circumstances to be able to terminate the contract for repudiations. Next, frustrations of a contract may occur where, without breach of contract by either party, a contract has become incapable of being performed because of current circumstances in which performance is required would render the contractual obligations radically different from those which was originally undertaken by the parties. If a contract is frustrated, the legal consequence is that the contract will be deemed terminated at the time of the frustrating event. Besides, on 23 October 2020, temporary measures for reducing the impact of coronavirus disease 2019 COVID-19 Act 2020 had come into force. The relief for the inability to perform contractual obligations could be found in Section 7 of the COVID Act 2020. It provides that the inability of any party or parties to perform any contractual obligations arising from any of the categories of contracts specified in the schedule to this part due to the measures prescribed, made or taken under the Prevention and Control of Infectious Diseases Act 1988 to control or prevent the spread of COVID-19 shall not give rise to the other party or parties exercising his or their rights under the contract. Take note that if the contract is not in the schedule, then the relief under Section 7 is not applicable. However, the minister still can modify the schedule by gazette. An important takeaway from Section 7 is that the inability to perform the contractual obligations must be related directly to the measures to stop the spread of COVID-19. This means that if the default occurred before the COVID-19 measures were undertaken or are unrelated to such measures, the defaulting parties will not be able to avail themselves of the relief under Section 7 of this Act. However, if a contract has already been terminated, any deposit or performance bond forfeits, any damage received, and any legal proceedings, arbitrations or mediations, commands, any judgments or award granted, and any executions carried between 18 March 2020 and the date of publications will not be affected by Section 7. And this is the list of the contracts that were Section 7 could apply. Next, Section 9 of COVID Act talk about mediations. Any disputes arising from an disability to perform any contractual obligations in an exempted contract may be settled by way of mediations. In light of the use of the words may under Section 9, the mediations option is a voluntary one. If any party relying on the Section 7, then they shall justify the reasons how the MCO affected their ability to perform their obligations. Last but not least, the introduction of COVID Act is a step in the right directions in this unprecedented time. However, further amendments may be needed along the line once the Act is implemented to further improve or add to the prescribed measures to deal with the various issues arising from the pandemic. That's all from me. Thank you for listening.